1 out of 3 basically gets approved initially. And the other 2 out of 3, I would say another third of them are disapproved because the reviewing doctors that work for the agency that gave their opinions didn't have the right records. They didn't have enough records. And it's just, like I said, most doctors are really busy. They're overworked. Opinion letters are very hard to get, but we'll talk about that later. They're constantly on the run. And it's not just 8 hours a day for them either. So if they get a form from Social Security, it's not likely they're even going to respond to it. So just bear that in mind. So the initial reviewing doctor, what's he got? He's never seen you. He's never talked to you. He's never examined you. He's never questioned you. All he's got is like whatever those 2 out of 5 doctors responded with, and who knows what that is. So as a judge, I very rarely gave much weight at all to the initial denial of reviewing doctor.
Trying to think, anything else about CEs we want to give advice on, or
I don't think so, Peter. I'll keep it in the back of my mind here while we're talking about the other stuff.
Okay. So let's talk about kind of a little bit different than the CEs. Who is this? Sometimes you'll get, especially denials, if you're denied at application or reconsideration, not necessarily the hearing level, but you might see, actually at the hearing level too, if you're denied at the hearing level, you may see a doctor's name drop in all these decisions that you never saw for a CE, and you never saw them even as your own doctor. And
right.
What I'm referring to is the DDS doctor who makes an evaluation on the case.
Yeah.
Way behind the scenes. Can you talk a little bit about who that doctor is, maybe their relationship to the Social Security or the states they're in, and how much pull they have?
Okay, that's a good question. And so they do have doctors on staff. DDS does, the state agency, has doctors on staff who will look at the evidence and give an opinion early on whether you're disabled or not. And you get that review initially. There will be a doctor who will give an opinion based on what records are there. Now, the first thing to know about that is that the records that doctor is reviewing are very sparse. And if you're at a hearing and you're going to a hearing and you've probably been waiting a year and a half or 2 years, all that medical evidence that you're generating during that year and a half or 2 years before your hearing, that initial reviewing doctor never saw. Not only that, but I mean, I've had cases where I'll submit records on the initial. They want to know, there's a form you fill out. Who are you seeing? What's it for? And what's their address? And then they'll send out an inquiry. And it's not uncommon for a doctor, if he receives one of these, they're too busy to respond to all the mail they get. And it wouldn't be unusual for them to not even respond. So you've got basically a doctor who's sitting in an office for the agency, whether he's practicing medicine or not anymore, probably not. He's probably retired. And let's say it's an orthopedic doctor, and he's looking, you're claiming I've got lumbar problems and I've got lower extremity problems because I've got sciatica and constant back pain, et cetera, et cetera. He's going to look at whatever records the doctors respond with. And if you got 5 doctors and only 2 of them respond, he's not going to have a whole lot of basis for his opinion. And so this is one of the big reasons I think that the initial application approval rate, what is it, 37%, something like that?
Yeah.
That's pretty low. 1 out of 3 basically gets approved initially. And the other 2 out of 3, I would say another third of them are disapproved because the reviewing doctors that work for the agency that gave their opinions didn't have the right records. They didn't have enough records. And it's just, like I said, most doctors are really busy. They're overworked. Opinion letters are very hard to get, but we'll talk about that later. They're constantly on the run. And it's not just 8 hours a day for them either. So if they get a form from Social Security, it's not likely they're even going to respond to it. So just bear that in mind. So the initial reviewing doctor, what's he got? He's never seen you. He's never talked to you. He's never examined you. He's never questioned you. All he's got is like whatever those 2 out of 5 doctors responded with, and who knows what that is. So as a judge, I very rarely gave much weight at all to the initial denial of reviewing doctor. And that's one of the things the judge does is he's gonna weigh all these medical evidence, all these medical opinions in your file, and he's going to give them a certain amount of weight. And that's going to depend on a lot of different things, including how long the doctor has known you, whether they've examined you, whether they've ever questioned you, whether they've reviewed all of your records, the whole panoply of bases for an opinion that judge is going to weigh when they decide how much weight they're going to give a medical opinion. Initial review doctors, their opinions are, it's like I said, garbage in, garbage out. If they've only got 2 reports and they're not particularly favorable, that's the basis for their opinion. And what good is that, really? So,
right. One of the things that that's important for, I think, our listeners to know is that these doctors, you'll never see them, like you said.
Right.
They'll never ask you questions. They're never going to evaluate you as a person, in the same way that a consultative examiner would. This was a doctor who is basically hired to read your file, read your medical records, and give their opinion based off the medical records. Not
a very sparse medical record, mind you. Yeah.
Right. Not an opinion based off of anything that they've reviewed the individual with or look at the individual face to face. So it's a good point. And there's, like you said, so many cases coming through, at the application level and the reconsideration level that they're doing, I think they're doing the best that they can, but they do deny a lot, like you said. Yeah. Their opinions, what's interesting is that, a lot of times it's like a page long, and it just says, oh, I limit this person to medium work or based off the record, and boom, 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 boom. Maybe it's a couple pages long based off this. And then if you get a reconsideration doctor, they'll just say, we concur with the application denial, right? And I think that's why reconsideration is like a 90% denial rate, because they're just like, oh, we concur. So it's really interesting. I will say, though, I love that you did not give much credibility to the initial application doctor. Mm-hmm. I have seen other judges, and at this point, so have you, I'm sure. Yep. They will cite to the initial application doctor sometimes to justify their denial. Yeah. One day, you and I should do a podcast about what goes into a written favorable decision and how that's done versus what goes into a unfavorable decision, because there is no in between. There is no like, I think this guy might be partially disabled. There's no in between in Social Security. It's either you're 100% disabled and we believe everything you say, or you're not disabled at all, and I'm going to throw everything in the kitchen sink in this decision, including the application doctor who did.
Right. Yeah. Yeah.
And I've seen a lot of decisions do that.
I'm sorry. I don't have a legal term for that. I would just call it cheesy.
But it's done. Like, that's what I mean. And
I know.
I get it from a judge's perspective, because they know that I'm going to appeal it, or most lawyers are going to appeal the hearing decision. and that their decision is going to be reviewed.
Yeah.
Either at the AC, and like our firm, we go to federal court, so we will hammer that decision.
Oh yeah.
So they're going to throw everything in the kitchen sink at it. And when clients read this, they're like, a denial, when they read a denial, they're like, I never even saw this, doctor. And I'm like, listen.
Yeah.
The judge made
or a CE. Yeah. A CE that's 15 minutes long.
Right.
Oh, that's totally inadequate basis for an opinion. Yeah.
But if they want to deny him, they're going to hang everything, take every evidence that makes the claimant look bad.
Yeah.
Exclude, discredit the good, and just, because there is no in between. And again, I don't want to go off on a tangent, but, these doctors at DDS sometimes get cited in these different decisions.
Yeah.
Because of that. And I know a lot of clients will call me and be like, who's this? I never saw this guy.
Yeah.
Let's talk about, I think, your area that you've probably dealt with a lot face-to-face is a medical expert at the hearing.
Uh-huh.
And my question about that to you is, and I don't want to get into too much of what they do specifically, like the listings, and I mean, we could do a whole hour and a half, a whole training session for young lawyers, probably for a couple of days, on how to cross-examine medical experts.
Mm-hmm.
Who are the medical experts? How do they get involved in hearings? What's their relationship to Social Security? What's their relationship to the claimant, the judge?
Yeah. Hopefully none. Hopefully they have no relationship with the judge. Right. Medical experts at hearing are, a judge can request a medical expert at hearing, and generally one will be provided. And they used to appear personally. And there was an orthopedic surgeon who was 98 years old when I was a judge, who would, you remember him?
Oh, I loved him.
Oh, he was but he'd been practicing law since before World War II.
Medicine. He'd been practicing medicine. There was two MEs. Yeah. There was two MEs that were that age, in their 90s.
They were, yeah.
Yes. Oh, I don't name drop them, but you and I both know who we're talking about. And
they were really good guys. And sometimes, I hate to admit this after the fact, but sometimes I would ask for Dr. So-and-so to appear just because I wanted to see him and chat with him a little bit,
Yeah.
But generally, a judge will ask for a medical expert on an area of medicine that he's not that familiar with, that the judge is not that familiar with. I always did. If I had cardiology cases, I would always do it because, I know basics. I know what the ascending and descending, arteries are, et cetera, but I don't, like, aside from ejection fraction, all the rest of it is like, what? So I get a cardiologist to take a look and give me an opinion at hearing. If I sent a claimant out for a consultative evaluation, and I still had questions about the report that came back from the evaluator, I might ask them to show up as a witness, and so that the attorney would have a chance to cross-examine them a little bit. And that's something you can always do. You can ask the judge to request evaluators or witnesses to appear personally. It's not frequent that a judge is going to allow that because they will take, 50 to 60 minutes for a hearing, and they don't have time to listen to a lot of witnesses. But they'll say, well, put something in writing. Well, the evaluator's already provided something in writing. So anyway, I'm the most interesting thing that I think about medical experts at hearing is that it's very rare to see effective cross-examination of a doctor by one of the representatives. For some reason, as you know, I've got substantial trial experience before I became a judge, and I learned how to cross-examine doctors 40 years ago, and so if there's a medical expert at hearing, I'm going to cross-examine him if he doesn't have a favorable opinion. And I've actually cross-examine doctors and had the judge, after they leave the hearing, the judge would say, "What a dummy," or something like that, because there are medical experts and there are consultative evaluators. There are doctors who are biased for Social Security. I don't know if that's because they want to please the judge. They think that, or they have a predisposition that, there's too many people on Social Security disability. We need to trim that back. I don't know what their motivation is, but there are doctors who have never seen a disabled person. They've never given the opinion that individual's disabled. And to me, they should be stricken from the list. And every year you can write to the agency and say, I think this doctor needs to be removed from the list, because if you review the cases they've testified in over the last year, not one, or very few, or rarely have they testified in favor of a claimant. On the other hand, you have not so much anymore. I haven't seen any doctors that are pro-claimant, but in the olden days, we had a few. So I don't know. I think it's important to have a representative who understands the medicine and is able to cross-examine that medical expert, because you don't know what they're going to say until they're in court. And,
Well, so a couple of things. One, I think you could absolutely teach a master class on how to cross-examine medical experts, especially for attorneys, young attorneys. Even myself, I'll sometimes go back and listen to your cross-examinations and require our associates to listen to them. That is literally a master class. I think just to, kind of summarize a little bit about the ME is that this is a medical expert who shows up to your hearing. Used to be in person, but now by phone or video. And even by video, you don't see them. They don't show their faces.
Right.
So it's a medical expert who shows up to the hearing. It is not a doctor who, again, like a little bit like the DDS doctor, it's not a doctor who is supposed to evaluate you. It's not a doctor who's sitting there doing some sort of, evaluation while you're in court. It's literally an expert witness in court or hearing that's there to talk about the medical records.
Yes.
And there to give their opinion.
Correct.
The listings, and this is generally how it goes. They're there to give an opinion. Does the claimant meet or equal a listing? The doctor will give that opinion. And then sometimes if they don't meet a listing, or even if they do, a lot of judges will ask, what is the residual functional capacity, either in a physical case or what criteria in a mental case, as far as social functioning and, et cetera. And that's sort of what they're there to do. And then the judge will ask that witness. Now, the Social Security Administration, not the state, the Social Security Administration, in my understanding, pays the doctor to be there, not the client.
They do. Yeah.
Right. And like you said, now, and in the old days, a lot of these doctors were just retired doctors that would show up to court. Are you seeing still that's the trend? It's still retired doctors, or are you seeing part-time clinician, part-time medical expert?